Hello, everyone, and good afternoon. My name is Halley Auger. I'm an employment lawyer at Samfiru, Tumarkin, joining you from Calgary, Alberta. I know for those of us who are in Alberta, Edmonton, I hear, is dealing with a little snow. Feel free to keep it up there. We had a little rain here in Calgary today, but hoping to stave it off in the meantime. I know Bubbles, my little dog, went out and came back with some wet paws today and made a mess everywhere in the house. So hopefully we've got drier weather coming up. We're here today to answer any of your questions live that you have respecting employment matters. I know things are a little nerve-wracking in the news right now. We've got some interesting news coming out from the federal government. The government is introducing $6 billion in aid to support Canadian businesses throughout the trade war with the US. So we actually have some good news coming out for both employers and employees. Good news for employers, there's $5 billion in funding over the next 2 years for Export Development Canada to help Canadian exporters reach new markets and navigate the economic challenges posed by the US tariffs. Employers directly affected by the trade war will also be able to get favorably priced loans to the tune of $500 million through the Business Development Bank of Canada. And the agriculture and food industry will be getting $1 billion in new financing through Farm Credit Canada. We've got some good news coming out for affected employees as well. The federal government is also implementing new temporary EI or employment insurance measures to support Canadian workers whose jobs have been impacted by the US trade action. So the pilot program is in place for the next 6 months. It allows claimants to receive EI benefits sooner because it's suspending the rules around treatment of severance, vacation pay, and other monies that are paid upon separation. So ultimately, this means that Canadians can get their severance and EI for the same period of time. Usually you had to wait out until your severance or your termination pay was exhausted, as well as vacation pay was used up before you could qualify for EI. Now you can get both at the same time. Waiving period waiting period's been waived. So normally you'd have to wait a 1-week period for your EI benefits. Now all claimants are able to get their benefits immediately. The government is artificially boosting unemployment rates by 1 percentage point. So with an inflated unemployment rate, that means that it reduces the number of hours that an employee needs to qualify for regular benefits. So you don't need any more than 630 hours anywhere in Canada in order to get your EI benefits. You're also up to an additional 4 weeks benefits. The federal government is also expanding the EI work sharing program. This allows employers to keep employees working even on a part-time basis with income support from the EI program. So normally that plan had a program that could last for 6 to 26 weeks, and now it's been extended to 38 weeks. And in fact, maybe it could even be temporarily increased to 76 weeks. Our employment lawyers at Samfiru Tumarkin are going to be meeting tomorrow. We have a national employment meeting, and hopefully we'll have some updates for you after that. If you're interested in this topic or other employment law topics, you can visit our website and then go to the Knowledge Center tab and click on blogs and news. You can register actually so that you can get updates on all our new blog posts. Okay, let's turn to the questions we have today. Barney ZZZ asks, will they also be changing layoff rules? So I don't believe I've seen any changes to the layoff rules, although if you are temporarily laid off, That's when your employer says that you're laid off for a period of no more than 90 days in a 120-day period. You are eligible for EI. And so while your employer might not be providing you with termination pay or severance pay, you're immediately going to be eligible for EI. That's my understanding. All right, a question from YouTube from Philip. My employer issues a yearly policy review that all employees need to sign. We don't get anything in return. Are these legally valid? That's a great question, Philip. And it really depends on if the policies are being changed, and if so, if they're taking away anything that an employee had. So certainly an employer is allowed to have workplace policies, and they're allowed to amend those workplace policies. But if the policy is taking away a benefit, that's when we start to get concerned. Normally, policy changes are not a worry. They have to be updated, as new things occur. There needs to be new policies in place to address any issues that arise. The things that employment lawyers are really concerned about are changes to policies that affect things like an employer's ability to make fundamental and unilateral changes to your employment relationship. So we're really concerned with policy changes that say they can reduce your hours or reduce your pay or, drastically change your workplace location. That's when we're concerned. We're also concerned if the policies attempt to limit your rights on termination. So if the policy is trying to limit you to only the mandatory minimum pay under the Employment Standards Code, instead of what you may have been entitled to prior to the policy being in place, which may have been up to 24 months severance. So that's the concern. But if Philip's employer is simply having employees refresh themselves on the policies that have existed during the course of employment, or if there's just small changes, then I do think it's legal. If your employer is trying to make fundamental changes to your employment relationship that takes things away from you, then your employer should be giving you something in exchange. In law school, we learned about something called the peppercorn rule, and that's because you have to get something that has the value of at least a single peppercorn in order for those policy changes to be binding. So if you're concerned that your employer is trying to fundamentally and negatively alter your employment relationship with the changes of policies, please don't hesitate to reach out. We are happy to review the circumstances and let you know if you may have a case for constructive dismissal, in which case you may be entitled to severance up to 24 months. All right. Question on Reddit from Fearing Fragrances. I have allergies to artificial fragrances and have communicated this to my employer. Despite my workplace having a scent-free policy, one of the staff continues to bring in heavily fragranced items. After having a severe reaction, my employer has told me I'm not allowed to return until I get my allergies under control. Is this legal? Well, that's an interesting situation. Employers have an obligation to keep the workplace safe. And that's why fragrance-free or scent-free policies usually fall under occupational health and safety. So it's a good first step that your employer has a policy, but the employer needs to enforce that policy. If the policy puts the burden on employees not to bring fragrances or heavy scents into the workplace, they should be enforcing that on those employees. Shouldn't be on the employee who has a reaction to scents to have to remove themselves from the workplace. This could also potentially fall under human rights legislation with discrimination, because if you have a medical condition that makes you sensitive to fragrances or scents, your employer has an obligation to accommodate that medical condition to the point of undue hardship. And I cannot see it being undue hardship to enforce a fragrance-free policy in the workplace. So you do have an obligation, though, to make sure that you're receiving treatment. If you can, be treated, and there's things you can do. You should be doing anything you can, but your employer can't force you into having sort of like a medical treatment, if they can simply enforce a policy that they already have in place. For fearing fragrances, I suggest you do put your concerns in writing to your employer, and rather than having just conversations. I hate to say it, but sometimes you're simply creating an evidence trail if ultimately the relationship breaks down and you're no longer able to participate in the workplace because of the sense in the workplace. So keep things in writing. If you want some further advice on this, please don't hesitate to reach out to our firm, and we'll have you booked in with one of our lawyers who can provide you with some highly specialized advice on your situation. You can go to employmentlawyer.ca. All right, a message from Laura. As an employee of an American company who works remotely in Canada, what are my rights if they let me go or try to change my job? So as a Canadian employee, I'm taking it when you say you work remotely, you're a Canadian employee, your entitlements are governed by the legislation that's in place where you perform work. So if you are performing your work in Canada, you're a Canadian employee and you're subject to that province's employment standards. So your rights are governed by that legislation. If your employer tries to let you go, I mean, as if you hadn't said if you're unionized or not, but I'm assuming you're non-unionized. Your employer is allowed to terminate your employment, for any reason, as long as it's not discriminatory, and their obligation to you is to provide you with reasonable working notice. They can say, okay, Laura, your last day of work is someday in the future, or pay in lieu of working notice, which we colloquially refer to as severance. That's the amount of money that you would have earned had you received working notice. And so if your employer pays you reasonable pay in lieu of notice, then they're free to do so. Laura has a second part to her question, and that's if they try and change my job. So it does mean that you have to take a look at your employment agreement and see what you agreed to at the outset of your employment about your employer's ability to change your job. If the job change is substantial and it's adverse, or meaning negative, you could be in a constructive dismissal situation unless you've contractually allowed your employer to make those changes to your employment relationship. Okay, so nothing really changes, Laura, that you work for an American company. As a plaintiff lawyer, I sue American companies all the time, and they have to treat my clients in the same way as my clients who are working for Alberta companies. So not a lot changes. Okay, a message from Complicated Topics. Based on that username alone, I'm nervous. Can my employer force me to follow company policy that is against my restrictions? I'm restricted from approaching shoplifters, but my HR says I have to do it. Complicated Topics, feel free to write in with a little bit more details. Who has restricted you from approaching shoplifters? If HR is saying you have to do it, are you in security? Or are you, working in sales? Like, are you a cashier on the floor? And what is HR saying that you have to say to the shoplifter? I'm not exactly sure what the company policy is. Now, this may fall under occupational health and safety. So employers have an obligation to keep the workplace safe. You also have a right to refuse work that's unsafe. Certainly, that means refusing to do work that is, dangerous. People typically think of, dangerous work, having to work at the top of a building without safety precautions, or work without, PPE, having to work in very, very hot or very, very cold weather. but you also have a right to refuse work that puts you in danger. And if your concern is that approaching shoplifters is going to put you in danger because you don't have training and you're not a security guard, then certainly you have a right to refuse that work. So feel free to write in with a few more details and we can make sure that we're answering your question, okay? Okay, resounding notes. If an employer tells you to do something that is in direct violation of their policy and then fires you for it, is that wrongful dismissal? Again, I need a little bit more details about what the employer is directing you to do. But again, I mean, if it's an occupational health and safety issue, for example, certainly that can be retaliatory. Now, again, this goes back to your employer's ability to terminate you for any reason that's not discriminatory, and that's not retaliation for raising a safety issue. When people talk about wrongful dismissal, what a dismissal is wrongful if you are terminated without just cause and not provided adequate notice or pay in lieu of notice. That's what makes a termination wrongful. So your employer can terminate you if you are not following a policy, if you are refusing work because it's in direct violation of one of their written policies. They'd certainly need to hear a little bit more about what that policy is and about how they're directing you to do work that they're telling you in one policy can't do. It is unfortunate. We do see employers who have policies but don't seem to enforce them, just like fearing fragrances had raised. And so a policy that isn't enforced is meaningless. My concern with resounding notes is that this might be a safety issue, so feel free to write in and provide a few more details. Okay, question on Facebook from Wanda. I was placed on a PIP, so that's a performance improvement plan, for productivity reasons. If my employer decides I have not met their improvement requirements in a given time frame, does that mean they can let me go for cause? Question, I won't be eligible for EI. Great question, Wanda. Performance improvement plans are very, very hard for a court to deal with. And the reason for that is an employer is setting some performance standard. Maybe it's a sales metric, let's say that. And for a court to have to decide if that sales metric is reasonable would mean that the court has to look at sort of the factors that go into that region and maybe what's going on with the economy and what's going on with competitors. So it's really, really hard for an employer to terminate for poor performance. In rare circumstances, employers may be able to establish just cause, but the performance metrics under the performance improvement plan have to be reasonable. You have to actually have an ability to meet them. They have to be clear. You have to understand what the metric is that you have to reach. There has to be enough time for you to meet it. So, for example, if you have $1 million sales target and you're at, 500 grand by December 1, your employer, can't say, well, you have to hit $1 million by the end of December, we fire you, because that's not enough time. They have to give you enough time. They also should be giving you support and training. If someone's performance is lackluster, it may simply be because of a lack of training, and the employer has to provide the training and support to get that employee to meet the performance metrics. Often, and in overwhelming cases, we do see employers who may have performance improvement plans in place. They may end up terminating the employee, but it's a termination without cause. In Alberta, and as far as I'm aware, throughout Canada, there is no such thing as mere cause. Either an employer has just cause to terminate your employment, and just cause is significant serious misconduct, or they terminate without cause, in which case you're entitled to notice or pay in lieu of notice. There is no reduction to the amount of severance that you're entitled to because there's an allegation of poor performance. Whether you were an exceeds expectations, meets expectations, falls below expectations kind of employee, your entitlement upon termination is the same. So, to answer your second question, if your employer terminates you for just cause, not all is lost. It's very hard to establish just cause. Please apply for EI anyway. Service Canada will do an investigation and determine if the allegation of just cause actually rises to the level that would disentitle you to EI. Very often, the answer is no, it doesn't. So if you're in that situation, certainly reach out, because it doesn't sound like it would be a just cause situation. Reach out to our firm and we can help you negotiate some severance, and we can actually help you guide you through an EI decision on your file, or even an appeal if EI has initially already denied you on the basis of just cause. Feel free to contact us. All right. Question from Eliza. I had an LMIA work permit with the company and it just expired, and they are giving me 3 weeks notice, but I got my PR. They laid me off saying we're overstaffed. Is this legal? Well, if your employment is not tied and your PR is not tied to your employment, your employer is allowed to terminate you at any time and providing you with notice. So if they've given you 3 weeks notice, that must mean that you're an employee of 4 years or less. That's maybe a little bit more than the Employment Standards Code pay. Generally, when somebody's entitled to notice or pay in lieu of notice, it's based on 4 main factors: age, length of service, character of employment, meaning what you did, and availability of comparable jobs in the marketplace. Now, if you have an inability to get comparable employment because of your PR status, that could potentially increase the amount of severance that you're entitled to. However, it may also have impacts on your ability to get a new job and have a new employer take over your sponsor under your PR. I apologize, I'm not the most familiar with immigration law. It's certainly outside of my wheelhouse. But if your employer is giving you 3 weeks notice and there's nothing in your employment contract or your immigration papers that have your employer being restricted from being able to terminate you, your employer still is allowed to terminate you for lack of work because you're overstaffed. The other question I have for Eliza is whether you have a written employment agreement, and if that employment agreement is for a fixed term, meaning it has a start date and an end date, or if it's for an indefinite period of time, because that can change the analysis as well. If you have a written employment agreement, and you may want to have that reviewed by an employment lawyer to look at your entitlements. So please don't hesitate to reach out, employmentlawyer.ca. We've actually come across this issue before, Eliza, so even though it's certainly not with immigration isn't within my wheelhouse, employment matters within the context of immigration, we're certainly happy to deal with. Okay. Oh, we're back from Resounding Notes. Resounding Notes had the question about a direct violation of a policy that he was being told to do anyway. So Resounding Notes says it's a safety and equipment operation policy. It states that you must receive training before using any of the equipment on site, and you can only operate what you're trained to use. Well, I mean, I hate to say it, but I mean, duh. Absolutely. An employer should have a written policy, or it should even be an unwritten policy, that you can't work on a piece of equipment unless you have training, and that you can only use it. So if your employer is asking you to work on a piece of equipment that you're not trained for, you have a right to refuse that work. It's under occupational health and safety. If your employer retaliates against you, either by cutting your hours, moving you shifts, demoting you, terminating you, You can file a disciplinary action complaint under occupational health and safety. There are very short timelines to do it. Under occupational health and safety, you only have 90 days to file one of those complaints. And the reason for that is because it is a safety concern. And so occupational health and safety is a governmental agency. And so their interest is in protecting the safety of workers. And so they want to make sure that they're moving quickly on safety matters. So do make sure that if you are retaliated against for refusing work because it's unsafe, that you do take very quick steps to file, we call that a DAC, disciplinary action complaint. All right, complicated topics. I work as a manager for a large retail chain in Canada. I'm currently in the return to work process. In the past 5 months, my employer is not willing to accommodate my restrictions approved WSIB. Complicated topics, that is a complicated topic. So if you're in WSIB is similar to what we have in Alberta, WCB. If you're receiving pay through WCB or WSIB, it does affect your employer's obligations to accommodate you. And so you may want to check with either a disability lawyer or one of our employment lawyers to see what obligations your employer has to accommodate you. For employers that are refusing to accommodate, the test is whether they can accommodate to the point of undue hardship. And so oftentimes employers can do a lot, with small changes to schedules, changes to work conditions, lifting restrictions, standing restrictions. There are things that employers can do that would allow an employee to return to the workplace and have the dignity of participating in the workforce. Lots of people don't want to be on WCB or WSIB. WCB and WSIB, as far as I'm aware, at least in Alberta, WCB doesn't pay full benefits. It's 90%, and oftentimes it caps out. In Alberta, I think it's 106 grand a year. And so people often don't want to stay on WCB. And if employees and their medical practitioners believe that they're in a position that they can return to work, with restrictions, employers should be accommodating those. We do see a lot of times employers not accommodating return to work plans and saying, well, you're on a 3-month return to work plan where you can't work full time for the next 3 months. Just stay on WCB or WSIB until your 3 months are up and then come back to work. Sometimes that can be an honest reason, and sometimes that's a dishonest reason. Sometimes the employer is looking to terminate your employment and can't do it while you are in an accommodation process or still suffering from a disability. So your red flags might want to be up if your employer is refusing to accommodate a return to work plan, and you're concerned that your employer is playing funny games and maybe looking to terminate you upon your return. You may have a claim for severance up to 24 months, and you may also have a claim for human rights damages. So please don't hesitate to reach out to our firm, employmentlawyer.ca. Okay, one last question if I can get it in. Question from Ninja Reel. The company I work for handles subcontracting tech support for other companies. I've worked on the same account for the last 7 years. The client is ending their contract. My employer wants to move me to work with a different company, but it's a very different job and will be in person instead of remote. If I do not take the role, they say I am quitting. Is there no other option for me? Well, I mean, if the client is ending their contract, certainly your employment has to be moved over to another account. Your employer should be looking to ways to not negatively adverse you. So we don't want to see any changes to compensation. We don't want to see changes to work environment. But if you have an employment agreement, that allows them to move you from remote work to in-office work, you may be hooped. But if you don't have a written employment agreement, you may be able to insist that you still do work remotely. Do not quit. Do not let them take your resignation. Some employers just say, well, we're going to treat this as a resignation. That's not a resignation. Keep working with your employer. Ultimately, your employer can simply, in this case, terminate you. If they can't find another role for you, they can terminate you. But in that case, you're entitled to notice or pay in lieu of notice or severance, which may be up to 24 months. All right, so I'm glad we got that in. Thanks, everyone. Dan Balkaran from our Vancouver office is online tomorrow answering your questions at 10:30 a.m. Pacific time. So if you didn't get your question in today, get them in tomorrow with Dan. And I'll see you in a couple of weeks. Bye.